Well, my name is John Simpson, and I'm a partner at Duane Morris. What brought me and what made me interested in helping out with a veterans case is I come from a military family. My grandfather fought in World War II. He had a unit who was involved in the Battle of the Bulge. My father and my three uncles were all combat veterans, so I joined the Marines. I was an infantry officer with the 1st Marine Division. And that's all I've ever known, both as a child and as an adult. So that's what brought me to this particular matter and gave me an interest in veterans issues. The case that got me involved and which we're talking about today is one that came to us being Duane Morris in May of 2020. So we interviewed a veteran who came through the TVC in a Zoom call environment. And I was one of several lawyers on the call. And what struck me about this case, after we talked to the veteran and after we reviewed her records, is that she had gone through a series of administrative foul ups connected with her discharge while she was in the Air Force and was I think incorrectly labeled when she was discharged with the reason for separation being personality disorder, when in fact, the facts showed that before she enlisted, had been subjected to a violent rape. And when she came into the Air Force, was again violently assaulted by an intimate partner, airman. And so there was a pretty clear-cut case that she was a sufferer of post-traumatic stress. But the Air Force, for whatever reason, decided to process this as a personality disorder case. If the mental health or physical condition is not a disability, it's a so-called non-disability condition, then you're administratively discharged and you don't go through IDES. In fact, you don't get anything. You're just tossed out of the military. So I felt like that was an injustice. So that case struck me as something that needed to be corrected. So that's why we took the case. We retooled it and then filed it before the board, the Air Force Board for the Correction of Military Records. They denied, they basically took the position that she did not have post-traumatic stress in the Air Force. When the Veterans Administration had concluded that not only did it exist in service by virtue of the physical assault in service, the prior condition was aggravated by that physical assault. That was the entire reason why they found it service connected. So they denied that it happened. They also denied, the medical advisor denied that the two physical conditions were unfitting because they were not would not have precluded her from performing her duties. So we put all this in. We waited, I don't know, more than a year, and what we got back was unbelievable. In about maybe a paragraph of reasoning, they denied the claim for medical retirement and basically said there was no injustice here. They went ahead and changed the narrative statement from personality disorder to condition, not a disability. So you think about, okay, well, that's a better outcome than having personality disorder. But at the same time, it's not true, because she did have conditions that were disabilities. And then they denied medical retirement altogether. So at that point in the case, we could have just dropped it and told the client that this is all we can do. Our engagement letter really didn't require us to go any further. But it just struck me that, again, how does something like this take place? This is someone who served her country honorably. So we decided, all right, we're not going to live with this decision. So what do we do now? So the next step would be a lawsuit challenging the validity of this decision. And I decided that the best way to do this was the U.S. Court of Federal Claims. And so we filed it in the Court of Federal Claims. We're going to lay this out. We're going to lay out this entire case. We're going to put in the details. We're going to put in what the Air Force did. We're going to put in citations. So we filed the case. Well, I think the strategy of laying the case out worked because we never had to do a trial. We never had to go the distance with a big motion for judgment on the record. The government came and wanted to settle the case based on what the complaint said. And so basically what they agreed to do is what we demanded. And therefore the orders were issued as if she had been medically retired and is entitled to receive whatever an Air Force staff sergeant with 6 years service would have gotten at that point in time. And on top of that, they agreed to give her back pay from the period of time when she was actually discharged up until the period of time that her enlistment would have expired. So it was a good result for the client. I've been practicing law for almost 50 years, and this case that I got involved in was one of the most rewarding experiences I ever had as a lawyer. In this particular case, and you don't get this very often, the client actually told me that I'd given her a reason to live. And that's why you need to do the right thing. And that worked in this case. And I think it's something that I'll never forget and I'll carry the rest of my life.